Every year, a massive river of capital flows from Washington, D.C. directly into state budgets. This federal money forms the backbone of local infrastructure. It pays for crime prevention initiatives, subsidizes food security programs, and bankrolls scientific research. Because these are long-term projects, state governments operate on a core assumption. Once Washington promises a grant, the money is locked in. States build their entire multi-year budgets around that guaranteed stability. But that stability was suddenly threatened when the Trump administration attempted to unilaterally pull back billions in promised funding midstream. The administration didn't attempt to pass a new law through Congress to make these cuts. Instead, they scoured existing regulations, searching for a hidden loophole that would let them enact a sweeping political agenda on their own. They found their leverage inside a dense bureaucratic rulebook, managed by the Office of Management and Budget. Buried in those pages was a civic clause, originally introduced back in 2020. It was then revised in 2024, during the Biden administration. Despite sitting in the rulebook for years, this language had never actually been used to terminate active state grants. It was a dormant technicality. The text states that federal agents can terminate a grant if the award, quote, no longer effectuates the program goals or agency priorities. The administration focused their entire strategy on exactly two words, agency priorities. They interpreted this phrase as a blank check. If their political goals shifted, they argued they had the inherent authority to retroactively cancel any funding that no longer aligned with those new views. By weaponizing a single bureaucratic sentence, the administration threatened to break the basic trust between state budgets and federal promises. If priorities change in Washington, local programs could lose their lifelines overnight. The executive branch rested its case on a simple premise. A new administration inherently brings new political priorities, giving it the right to terminate previously awarded grants that don't fit that vision. This interpretation immediately put billions of dollars in active state funding squarely on the chopping block. The backlash was swift. A legal coalition of 23 separate states rapidly formed to block the proposed cuts. In their lawsuit, the states accused the Office of Management and Budget of using the clause to justify a nationwide slash-and-burn campaign. They also raised a broader concern. Allowing this interpretation would hold essential local programs hostage to the personal whims and political ideologies of whoever happens to occupy the executive branch. What began as an argument over an obscure budget regulation quickly escalated into a high-stakes constitutional battle over who actually controls the federal purse strings. The conflict ultimately landed in a Boston federal court, where U.S. District Judge Indira Talwani stepped in to issue a ruling. She determined the administration's aggressive interpretation was completely unsupported. It lacked backing from both the actual text of the provision and the history of how the rule was made. This chart breaks down the primary legal roadblock defeating the administration, the Constitution's spending clause. It strictly requires any conditions tied to federal money be imposed unambiguously. Practically, the government cannot retroactively alter rules. Once committed, the law locks those conditions in place. With that constitutional hurdle affirmed, Judge Talwani granted a summary judgment, entirely barring the administration from relying on the obscure clause to make their funding cuts. The ruling established a critical constitutional guardrail. It proved that while the executive branch holds vast administrative power, it cannot unilaterally rewrite the fine print to bypass Congress and defund the states.